All right, are you Zakarian Wagner?
No.
And Mr. Wagner, in cause number 24, DCCR 0912, is on probation for tampering or fabricating physical evidence with intent to impair, was placed on probation for a term of 10 years, ordered to go to ISF, and then there was a motion to revoke community supervision filed. We were here previously. Pleas of true were entered in counts 1 through 7.
Actually, Judge,
Is that not correct?
That's not what my notes reflect, I believe.
Let me pull up my actual.
Yes, he pled not true to 1 and 2.
And 6
True-
was abandoned.
6 was abandoned, and true to the remaining counts.
Does the state have evidence with regard to those new offenses?
No, Judge.
Okay. Hold on, let me pull it up. Okay, so the pleas of true, the updated report is not correct. The pleas of true were to counts 3, 4, 5, and 7.
That's what my notes
That's
reflect.
correct, Your Honor.
Counts 1 and 2 related to
Indiana.
Indiana cases, and so the state is unable to have evidence with regard to those. Is that correct?
Yes, Your Honor.
So the counts 3 was a void association with anyone previously convicted of a crime. Count 4 was not to leave the state of Texas without prior approval. Count 5 failed to report by mail as directed, and count 7 was fees and being behind in fees, correct?
Yes, Judge.
I have received the updated report, and also I have received jail
Buckle up, guys. Today we are going inside a tense courtroom where a young defendant is immediately placed under heavy judicial scrutiny from the very first second. The judge begins by identifying Zakarian Wagner and laying out his probation background tied to tampering with evidence. A long supervision term of 10 years is mentioned, immediately showing how serious the original offense was. The tone is formal, controlled, and already leaning toward accountability rather than sympathy. Even before any argument begins, the court establishes a history of supervision failure. You can feel that this is not a fresh start situation. Instead, it is a continuation of repeated legal consequences catching up. The atmosphere sets up tension for what's about to unfold.
incident reports. Has everyone had an opportunity to review all of those?
We have,
The state has, Judge.
Are there any additions or corrections to that updated report, other than the pleas of true that I just corrected?
no, Your Honor.
Not from the state.
Okay, Mr. Rojas, you may proceed.
Thank you, Judge. Regarding the incident in Indiana, because he did plead true to leaving the county and being in Indiana, he tells me he had previously lived in Indiana. When he moved down to Texas, he left some things in his apartment in Indiana, clothing, furniture, things like that. He had a roommate here in Texas who was moving to Indiana, and at that point he had an opportunity to go back in Indiana with a truck and bring his things back. He should have asked for permission, Judge. He didn't get permission. He just thought he could make a quick trip to Indiana, get his things, and come back. And that at that point, when he was arrested with another person, he tells me the charges against him were never filed. The other person that he was with in Indiana is the one that was charged with those crimes. He's asking to be continued on to probation. And I'll talk about the reporting. He pled true to not reporting to Jefferson County by mail. He tells me he was reporting in person in Orange. He never failed to report in person in Orange. He reported all the times he was supposed to, and I don't see an allegation about that. So I tend to believe that's probably true. He didn't know he had to report to Jefferson County by mail. That's the reason he didn't do. He tells me that's why he didn't do that. Before he was arrested on the motion, he was working construction, doing guardrails on the highway with the Highways Department.
The court moves into the exact probation conditions, and this is where the structure of the case becomes fully clear and legally defined. The judge lists restrictions like avoiding criminals, not leaving the state, reporting requirements, and fee obligations. Each condition becomes a separate potential violation point that the state can rely on. The seriousness increases as every rule is placed clearly on record without ambiguity. This is a framework that will determine guilt or violation status. The defendant freedom is shown to be highly conditional, not absolute. The court is essentially outlining the boundaries that were allegedly crossed. It becomes clear that even small actions could trigger major consequences under probation.
Obviously, he lost that job. He says his mother has a friend who has a wood shop. He can get a job doing that if he were allowed to continue probation. He will be living with his mother in Orange, and so he's asking to be continued on probation. He's still a young man, Judge. He's 20 years old. Obviously, he's certainly old enough to know better than to go out and do these things, especially being on probation. But I think he's still young enough to not really understand fully the consequences of what's going to happen to him if he doesn't. I think this has been a wake-up call. He's been in jail since September, I believe. Again, we're asking you to keep him on probation, let this time in jail serve as sanctions, and I don't know what other classes we can give him. He's already been to ISF, but obviously whatever conditions the court thinks is appropriate, he would follow.
So the person that you were with, that you got in trouble with up in Indiana, has a motion to revoke his probation here in Jefferson County too, correct? Mr. Dyer, Jacathan Dyer.
Do you know about that?
I think that's what he went in for.
What?
I said, I think that's what he went in for as well.
Real quick too, so the allegation of failing to report by mail or online was for May, June, and July. But he had been on probation for several months prior to that. So had he reported online or by mail prior to those dates?
He had been in custody waiting to go to ISF, but he had a pending charge in Harris County. So he had to be transported to Harris County, take care of that, and wait for ISF, then go to ISF.
Okay. And what was that, Harris? I don't remember that.
The defense begins explaining the Indiana incident, attempting to reduce its severity by framing it as a personal trip. The claim is that the defendant only went to retrieve belongings and had no criminal intention. However, the legal issue immediately becomes permission, not intent, which weakens the defense position. The judge focuses on the fact that travel occurred without approval. That alone becomes probation violation, regardless of personal reasoning. The explanation sounds emotional, but struggles against strict legal conditions. The courtroom dynamic shifts towards skepticism. What is presented as a practical decision starts to appear like a clear breach of supervision rules.
Unlawful carrying of weapons.
What was the outcome of that case?
They dismissed it because of us sending him to ISF.
Your Honor, just briefly, Judge, the tampering with evidence offense as the defendant pled to is a little misleading in that what he tampered with was a firearm, Judge. When law enforcement encountered this defendant, he had one weapon that they initially discovered, if I recall correctly, and then when they put him in the back of a patrol unit, the patrol car video captures him essentially while handcuffed, dumping another weapon. That weapon was outfitted with what was tantamount to a Glock switch. And I say tantamount to a Glock switch because when ATF tested it, it did not meet all of the requirements to be technically a Glock switch. So he dodged a bullet on, well, no pun intended, dodged a bullet on federal charges, Judge, because we were looking at potential federal charges with the Glock switch. So there's two firearms that he was in possession of. Then he's got the unlawful carrying of a weapon in Houston, albeit eventually dismissed. I'd ask the court to take that into consideration. This defendant has an affinity for firearms, and not only firearms, a Glock switch, Judge, you know the damage these Glock switches could do if that was a fully functional Glock switch, Judge. I'd ask that this court revokes the defendant's probation and send him to prison, Judge. And of course, that amount of prison is at the court's discretion. I do understand that he's a youthful offender, but Judge, you know, these youthful offenders with these guns and Glock switches, they're wreaking havoc in our community. And And at a certain point, we send a message. I'd ask the court to send that message today, Judge.
Now, the focus moves toward reporting violations and the defendant's employment situation. The defense tries to argue compliance through in-person reporting and suggests there may have been misunderstanding regarding mail reporting requirements. There is also an attempt to show stability through work history and housing plans. These details are meant to support continued probation instead of revocation. However, the judge is now comparing claims against documented violations. The gap between explanation and record becomes more noticeable. This creates rising tension in the courtroom. The more the defense speaks, the more the case feels like it is being tested against strict accountability standards.
That's all.
Thank you, Mr. Coleman. And Ms. Martinez, thank you for being here. Do you have anything to add that's not already in your updated report?
No, ma'am, it is hard to supervise someone who almost immediately leaves the state without reporting it or requesting permission. We wouldn't have known he was up there if they hadn't called us to tell us that they were in custody of their jail.
I mean, Mr. Wagner, the problem here is that I did with you what I do with a lot of youthful offenders, is we give you that opportunity on probation. I send you to ISF up front so that you have the tools to make better decisions so you can be successful in your probation. So I don't have any other tools because I already did that. And your history, so it's not like you just started getting in trouble once you turned 18 or 19. You've been to TJJD. So you were a youthful offender, so much so that they didn't just put you on probation as a juvenile, you ended up going to TJJD. And it takes a lot, in my opinion, it seems like sometimes, for these minors to be sent there. So you must have really frustrated and done something to end up in juvenile prison. Then you get out and you're doing the same thing, and I don't. So you went to ISF. So April.
The prosecution escalates the situation by connecting the defendant to another probation violator arrested in Indiana. This is important because it suggests prohibited association, not just a travel violation. The argument now shifts from technical breach to behavioral pattern. Being found with another offender raises concerns about judgment and compliance. The state uses this to show repeated disregard for supervision boundaries. It is no longer just one mistake, but a network of questionable decisions. The courtroom tone becomes more serious and less forgiving. Each new detail increases pressure on the defense narrative.
7th of 25, you get dropped off when you were discharged from the ISF to probation. Placed on a mail-in caseload, courtesy supervision was accepted by Orange on May 21st. 2 months later, you're in Indiana in jail in Indiana with someone who's also in trouble in Jefferson County that probably wasn't supposed to be or didn't have permission to be in Indiana either, I'm guessing. In addition, we have jail incident reports where you prove to me that you don't want to follow anybody's rules. You obviously don't want to follow probations, and you don't want to follow the correctional officers. You are calling names. I can't even say the words. You're gonna slap the F out of the correctional officer. That's great. You're going to everything is just you telling them, I'm going to do this my way. I'm going to shower when I want to shower. I'm going to wear my clothes how I want to wear my clothes. I'm going to tell you to hush when you're talking to me. I'm going to call you names. Here's one even worse. I'm not going to say these words. Yeah. All right. I'm going to find that you entered your pleas of true to counts 3, 4, 5, and 7 freely and voluntarily. This frustrates me so much, Mr. Wagner, because you've given me no chance when I gave you everything.
The case takes a dramatic turn when firearms enter discussion, significantly raising the stakes. Allegations include multiple weapons and a modified firearm device, described as extremely dangerous. The mention of a Glock switch elevates the seriousness to near federal concern. The prosecution argues it shows a pattern of dangerous behavior, not just probation violations. This shifts the case from supervision failure to public safety risk. The atmosphere becomes noticeably heavier as the judge listens closely. What started as probation issues now feels like a major criminal threat evaluation. The stakes are now at their highest point in the entire proceeding.
Chance. You have no choice at this point, in my opinion, because you refuse to follow anybody's directions, and that means our community is not safe if you're in it. I'm going to find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering or fabricating physical evidence. Sentence you to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not a plea agreement. You can talk to your attorney about any possible rights to appeal. I need y'all to sign that, and then you'll get your copy. Also, I'm handing you a written admonishment regarding your ineligibility. Go ahead and then I'll read this. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. You are still young. You can make the best of the time that you've got and get out and do better, or you can get out and do worse and be right back in here. So I hope you take advantage of doing better with your life. Go back with the bailiff. Good morning, sir. Are you Alvin Wade?
Yes, ma'am.
And Mr. Wade, in cause number 25, DCCR 1648, you're charged with a third-degree felony.
The judge reflects on the defendant's background, including prior juvenile detention and rehabilitation attempts. There is visible frustration as earlier intervention opportunities are referenced. The court highlights that structured programs were already provided, including ISF support. Despite those chances, violations continue to occur. This creates a narrative of repeated failure rather than isolated mistakes. The judge's tone shifts from neutral assessment to disappointment. It becomes clear that patience is running out. The courtroom begins to feel like a final evaluation rather than another opportunity.
Offense of possession of a prohibited substance in a correctional facility from July 6th of 2024. Your indictment alleges that you were previously convicted of aggravated sexual assault on a child, a first-degree felony, January 22nd of 1998, and after that was final, you were convicted of failure to register as a sex offender, a third-degree felony, November 26th of 2018. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand the possible range of punishment if you're found guilty at trial?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature with Mr. Rojas's and shows that the district attorney's office has made an offer, if you would like to enter a plea of guilty, for a 15-year term in prison. So that would be to go on counts 1 and 2 only. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
With counts 1 and 2.
So counts 1 and 2, that just makes it a second-degree felony instead of the habitual. So it's the offense you're charged with and one of your priors instead of both of your priors. So that's how we get to 15 instead of that minimum of 25. Make sense? And so do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get your case set for trial, Mr. Wade.
And, excuse me, can I say?
Uh-huh.
I want to invoke my sister constitutional right.
To,
Speedy trial,
you're lucky because in this court, we only have 50 cases waiting on trial. So every case is getting a speedy trial now. So you will get set for trial as quickly as possible, and we'll get your case taken care of within a very short amount of time. Now, I wanted to ask you, Mr. Rojas has been appointed to represent you.
Jail incident reports are introduced, showing aggressive and defiant behavior while in custody. These include refusal to follow orders and verbal hostility toward officers. This is critical because it shows misconduct even under detention supervision. The behavior reinforces the idea that authority is consistently challenged. The court now sees a pattern across multiple environments. It is no longer just probation violation, but institutional defiance. This significantly damages any argument for leniency. The prosecution strengthens its claim of ongoing noncompliance.
He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release Mr. Rojas. I can appoint another attorney who could begin preparation for trial probably a little quicker. Is that okay with you?
will I have the same right to gather the evidence?
Yeah, of course. Your attorney will get all of the discovery. They'll go over all of that with you, and then we'll get your case set for trial.
And like pictures, I need him to take some pictures.
Just listen. Let's start with, do you want a different attorney so they can prepare quicker, or do you want to keep Mr. Rojas?
If you're gonna,
Any attorney,
he told me he was a cop outlaw.
I can't imagine that Mr. Rojas
Yeah,
used those words.
It's on the kiosk.
I said she'll give you a new lawyer if you want to. It's just somebody that can work better faster than you.
You say you're a cop outlaw, that they lead us with the DA. I need a lawyer that's gonna help me.
Any of the attorneys who I can appoint in my court are going to represent you to the best of their ability.
Your Honor, if I may, Mr. Rojas has negotiated with me back and forth on this case. We've discussed this case at length, both the strengths and the weaknesses in the state's case, just for the record.
I have no doubt that Mr. Rojas has done an excellent job already. But Mr. Wade, I just need to know if I have your permission to release Mr. Rojas and appoint someone else, or do you want to keep Mr. Rojas? Is that simple?
I'm gonna take your advice.
It's not advice. Don't be putting words in all of our mouths. I'm not giving you advice.
He was a good lawyer, huh?
I'm saying everyone on this list is a good lawyer. So you can keep Mr. Rojas, or you can get someone else off of the rotation.
The judge delivers a final ruling after reviewing all violations and evidence. The defendant is found guilty and sentenced to 6 years in the Texas Department of Criminal Justice. This moment marks a collapse of all defense arguments under accumulated violations. The sentence reflects both legal breach and behavioral concerns. A firearm restriction warning is also issued, emphasizing future consequences. The tone is final, firm, and irreversible. The courtroom shifts from debate to judgment. Everything presented earlier leads directly to this outcome.
Who could probably start your preparing for your trial a little quicker. Mr. Rojas just handles a lot of cases for me.
Okay. Then I need a lawyer that, when I handle my case is
Quicker, because you're asking for a speedy trial and all. Perfect. So I'm going to release Mr. Rojas. I will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes.
You can go back with the bailiff. You didn't get your copy?
No, Judge.
All right, let me hold it. There is a updated revocation of update.
Oh, there was an updated one. That's probably why. Okay. Judge, I'm ready to proceed. Okay.
Sure.
Yeah, I'm ready.
There's one that you can have.
Thanks. Yeah, if we could do a recall, if we could recall it. maybe
Absolutely.
Couple minutes.
I think that's important on this one probably.
Yeah, please.
Just go have a seat, sir. You are Kaisha White. Answer out loud, please. I'm sorry? Yes. This is 24 DCCR 2063. And Help me out. What are we,
We pled her back in January of last year.
it was a bond forfeiture.
And there's a bond forfeiture for the punishment hearing. Judge, in speaking with her in the back, she doesn't remember everything that happened last year. I would request a reset to get her evaluated.
Okay,
I don't know, I don't think she agrees with that, but I think that may be the best way to go before we.
well, and I'll, obviously, you're the one that's, speaking with her, and if there's any issue, then we want to make sure, that there is everything taken care of before we go forward with any sentencing or withdrawal of plea or anything like that, and so we'll do the order today. Ms. White, there'll be someone to visit with you very shortly, a doctor, to make sure that everything is okay with your understanding of the proceedings that are going on, and then we'll move forward with your case after that. So you can go back with the bailiff. You just go back with the bailiff.
Do I need to file a motion on that, Judge, or what?
Good morning, are you Carlos? Right here.
It's Spanish, Your Honor. Would you like me to interpret?
Can you interpret?
I can, yes.
That would be great if you would.
The courtroom continues with additional cases, showing the ongoing flow of justice beyond a single defendant. Topics include plea negotiations, trial scheduling, attorney replacement, and mental evaluation considerations. This highlights how continuously the court operates without pause. Each case carries its own urgency and legal complexity. The system is shown as procedural and relentless. Even after a major sentencing, the docket moves forward immediately. It reinforces the idea that justice is constant and ongoing. The environment remains structured, formal, and highly procedural throughout. If you enjoyed this breakdown, make sure to like the video and subscribe to the channel for more real courtroom analysis like this. We'll see you in the next video.